Hi everybody, Bill Prince here. We're going to spend a couple minutes talking about the material within Chapter 5, Business and the Constitution. I would just note that the material in this chapter could probably support an entire course, so trying to do it justice in just a few minutes may be a bit challenging, but I do want to hit some of the highlights related to the relationship of the Constitution and the legal environment of business. First of all, the important thing to understand about our country is that the system of government we have, a representative republic, is set up in a federalist fashion. Now, what that means is that when our country was established, there was a lot of conflict between those people who wanted to see a very strong central federal government and those who were worried about having a strong central government and thought that the power should best be left in the hands of the states. And so when the Constitution was drafted, which of course, as we will see, is the primary law of our land, a federalist system was set up. And what that means is that if you study the Constitution, you can see that there is basically a division of powers between the federal government, what it can do, and the state governments, what they can do. The default position is more or less, if it's not specifically stated that the federal government can do something, the states should be able to have that power. But as we will see, that has been a bone of contention basically since the ink was dry on the Constitution. Under our scheme of federalism, the Constitution gives the federal government certain powers with which it can act, and you can find a specific list of those powers under Article 1, Section 8, specifically clauses 1 through 17, and it includes everything from coining money to negotiating treaties to passing bankruptcy laws to raising armies, those sorts of things that would make sense to have a unified and consistent policy. For example, if we allowed every state to establish its own system of currency and monetary valuation, it would be very difficult to conduct any sort of business in the country. It would look like Europe before the euro. And so the founders gave the federal government the power to do those sorts of things. So again, if you look at those enumerated powers or delegated powers, you can see that that's kind of the theme there. The federal government also has the power to do those things that are necessary and proper to carry out those express or delegated powers that they are given. So, for example, in the slide, we talk about this idea that, if you go to the Constitution, you can see where it's specifically spelled out that Congress or the government has the ability to tax, but there's no mention at all of anything called the Internal Revenue Service or a tax code or things of that nature. However, because the Constitution gives Congress the power to do things necessary and proper to carry out its provisions, you need to have some sort of mechanism by which to create, collect, and enforce taxes, and so along comes the Internal Revenue Service. The federal government also has what are called concurrent powers with state governments, and these are powers that both the state and the federal government can engage in. Taxation is the most typical of those things. We get taxed at the federal level, at the state level, at the city level, at the county level, and so forth. As we will see, if there's a conflict between a state law and a federal law, however, the federal law is going to prevail. Under the scheme of federalism, if a power wasn't expressly spelled out to the federal government or deemed to be necessary and proper to carry out an express power, then all other powers were supposed to be held in the hands of the states. And this would include things like education, marriage laws, drug legalization, things of that nature. But as we all know, the federal government has gotten its hands involved in many of those areas, and much of that has been because of the fact that the federal government provides lots of money to the states for those kinds of things, and money can be a powerful tool to incentivize certain behaviors. All right, let's look at some clauses that are important to understand. First of all is the Privileges and Immunities Clause, which comes in Article 4 of the Constitution. And basically that prevents one state from treating citizens, be they human or corporate, differently from citizens of another state without a pretty good reason to do that. Think about how difficult it would be to conduct business if you had to worry about different regulations and requirements from every state. And while those do exist, we have sort of seen over the course of time sort of a standardization or uniformity of laws created across the states so that basically the laws of one state are similar to the others, hopefully when it comes to business practice. The second is full faith and credit. And full faith and credit basically requires one state to afford the laws and judgments of the courts of another state full faith and credit. Think of getting a judgment against one company, and then that company packs up and moves all of its assets to another state in order to avoid paying that judgment. If that other state didn't allow the judgment of the state where the judgment was obtained to collect, then it would basically make courts worthless in terms of enforcement or judgment. So if a judgment's entered in one state, a court of another state is required to give full faith and credit to that. And then the Commerce Clause, which is Article 1, Section 8, Clause 3, gives Congress the power to regulate commerce between foreign nations, with Indian tribes and amongst the several states. And one of the reasons that we've seen federal government get so much more involved in state affairs is because of the Commerce Clause. Depending on how broadly commerce is defined, it can have a major impact upon how involved the federal government can get in the roles of the states. So the Commerce Clause is very important, but it's clear that for sure Congress has the ability to make laws that are regulating business. So that's an important one for you to realize as well. It's going the wrong way there. Article 6 of the Constitution, the Supremacy Clause, basically says that the Constitution is the supreme law of the land and all other things must be consistent with the Constitution. And then there's that preemption doctrine, which basically says that a law that is made by a state or even a federal law that conflicts with other federal laws or the Constitution will generally be overruled by federal law. And then Congress has the power to lay and collect taxes, and taxes are obviously an important aspect of the legal environment of business. All right, let's talk a minute about the Bill of Rights. When the original Constitution was enacted, there was no mention really of the rights of the people and limitations on the government over those rights. And so a side deal was more or less cut, where once the Constitution was ratified, then there was an agreement that these 10 amendments would be placed upon it. And so the first 10 amendments to the Constitution are collectively known as the Bill of Rights. In most cases, courts have held over the years that the Bill of Rights applies not only to natural people, but also to legal entities and corporations in many cases. And when the Bill of Rights was first applied or adopted from about 1791 to 1864, 1865 or so, those protections only applied to the federal government. It did not apply to the states. But the passage of the 14th Amendment and what is called the incorporation doctrine dragged those protections through to the states. So now all states must follow the Bill of Rights as well. One of the most important of those protections is freedom of speech, which is contained in the First Amendment. And speech contained in the First Amendment that is protected includes things like words that would come out of our mouths, obviously, things that we would write down, symbols, flags, flipping somebody the finger potentially could be a protected free speech, burning flags, and that type of thing. There are no absolutes in our Constitution. In other words, there's no absolute absolute constitutional right. The government can limit those rights if it can show a compelling interest to do so. So, for example, while we have a free speech right, we may not have a right to run into a crowded theater and scream fire because the result of that could result in injury or harm. So that would probably be unprotected speech. There's also distinctions made between political speech and commercial speech, with political speech being much more protected than commercial speech. Commercial speech is things like advertising, and so business speech is not afforded as many protections as political speech is. There are also certain kinds of unprotected speech which the Constitution will not protect. Those include things like slander, libel, and those again are making false oral or written statements about people, defamation of character, obscenity, fighting words, those words that are said that encourage riots and things of that nature. Those are not going to be protected by the Constitution. A famous case, and I'm not sure it appears in your textbook yet, Citizens United versus the Federal Election Commission within the last 5 or 6 years has explicitly held that corporations now have free speech rights, not just their stockholders or owners or officers and directors, but the corporations themselves have free speech rights, and that was sort of a big deal. And basically in that case, the court further went on to hold that donating money to candidates or causes is a form of speech, and that limiting the amount of money that somebody donates to a candidate or cause is an impermissible limitation on speech. And so for all intents and purposes, that basically gutted all campaign finance laws, and now we just threw our elections open to unmitigated amounts of money. The Constitution also talks about I'm going to pause this for a minute because I don't know exactly where this slide came from. Hang on just a moment, please. Okay, we're back. Sorry about that. Apparently something got pasted to that slide that I did not intend to have pasted to that slide. The First Amendment also protects freedom of and freedom from religion. The Establishment Clause of the Constitution basically says that Congress shall make no law establishing a religion. And so obviously, that's pretty clear that the government couldn't all of a sudden one day say that, Catholicism or Methodism or Judaism is going to be the national religion. That's pretty obvious. But it also can't do things that pass laws that would favor religion over one religion over another. So, tax dollars to support religious schools, things of that nature have all run afoul of the Establishment Clause. And then there's also the Free Exercise Clause, which basically indicates that the government can't limit our ability to believe in things we want to believe in. Our founders knew that it was never good for the state to involve itself with religion. They also knew that it was never good for the state to tell people what they could believe or couldn't believe. And so people generally have a right to exercise their beliefs as they see fit. Again, so long as those beliefs don't run counter to state interests. In the slide, we indicate that if you belong to some sort of religion that believes in human sacrifice, you're not going to be able to kill people and plead somehow that you can't be tried because it's limiting your free exercise clause. So again, there's always that balancing act there. The Fourth Amendment to the Constitution limits searches and seizures, and basically indicates that we are to be secure in our persons, property, homes, possessions, papers, and things, and that the government is only to be able to search us or seize our property if there's a valid court order to that effect, or if there's probable cause to believe that we've committed some sort of an offense. And again, this has been held to include businesses as well as natural persons. And then self-incrimination, the Fifth and Sixth Amendment, people have a right not to be compelled to testify against themselves. In other words, in our system, the state has to prove that somebody's guilty of something. We don't have to prove that we are innocent. And so individuals have a right to not incriminate themselves. That would also include corporate individuals in terms of people working for corporations, but corporations themselves, that legal entity, cannot always claim the Fifth or plead the Fifth Amendment. One of the hallmarks of our system is what's known as due process of law, and there's a couple kinds of due process. There's procedural due process and substantive due process. Procedural due process basically talks about how our system works, and so before the state can uh, take our life, execute us, liberty, put us in jail, or property, take fine us or take property for eminent domain, that kind of thing. The government first has to provide us with notice and an opportunity to be heard before an impartial decision maker. And if the state does anything without those steps, then an individual or company would be deprived of their procedural due process. There's also what's known as substantive due process, and that's where we look more at the substance of a law. In other words, does the law that is impacting somebody serve a state purpose that is sufficient to justify that law coming into effect? And again, these are laws that deal with things treating people differently on the basis of sex, race, ethnicity, national origin, and things of that nature. And so generally a fundamental right, such as speech or traveling or privacy, or laws that impact classes, suspect classes of people, and again there we're looking at race, national origin, and ethnicity, those laws will not generally be upheld unless the government can show a really strong, compelling interest to treat people differently on the basis of those kinds of things. In all other cases, how old you have to be to have a driver's license, how old you have to be to drink, those kinds of things, those laws are going to be upheld so long as it is rationally related to any legitimate government purpose. All right, and finally, the Constitution, and we always talk about privacy as being a constitutional right, but there is no, the word privacy does not appear in the Constitution at all, and so this was a right that was created by the Supreme Court in case law, but basically, we have a right to be left alone as people in this country, and so there have been a number of laws that have been passed that sort of hang around the edges of our privacy law. There's the Freedom of Information Act, which would allow us to petition the state to find out things that it's doing, in particularly with relation to us. There's HIPAA, the Health Insurance Portability and Accountability Act, which prevents people who are in possession of information related to our health to share that. And again, this sort of came up when it was found that insurance companies were sort of sending our health information around, making it difficult for us to maybe get insurance. And then there was this thing called the Patriot Act, which came on the heels of September 11th of 2001, and it weakened many of the privacy rights that we had in the interest of national security. And so as a closing note, I would just kind of set forth a warning that be very careful of any law that wants to take away our constitutional rights on the basis of protecting us. Those laws are often dangerous and tough to reverse. So that's my nickel piece of advice for you today. So that's all we're going to talk about on this pretty important chapter, but we'll visit with you again in Chapter 6. Take care.